it's still a concept that, well, if you breach the legislation, it must be an offence. Now, to be fair, that would generally be true in legislation, and it sounds as though it should be true, but there is no suggestion of that in the Fire Safety Order. For a contravention to constitute an offence, there needs to be evidence of the risk of death or serious injury in the case of
what was acceptable in one area wasn't acceptable in another. Risk assessments seem to be driving clients mad. Even where they had a situation where they had a risk assessment which was generic, then made site-specific by a consultant who they believed was pretty good. They were rejected on the basis that they had an element of tick-boxing in it. There's been a lot of complaints that fire officers are looking for documents all in one place, as in the risk assessment, and don't understand that it might be in other manuals or other procedures. There was almost, I would say half, came back with a complaint about the pressure they're under to train everyone on the use of fire extinguishers. So there was a common theme that ran...
What defines enforcement is a matter of judgment. Enforcement comes at a cost. Most costs are easily identifiable, some are less so. Costs are contingent on the adopted approach, so it depends what your authority deems is required in your particular county. The approach is based on the extent of risk and what is reasonably practicable for each fire authority. Costs are therefore determined largely by individual fire authorities.